officially being recorded. So the session is now being recorded. So when we start this this interesting subject area of the law of persons, we're going to start with what does the law of persons determine? So law of persons basically determines four things. First of all, it's govern anyone capable of having rights and duties. That is very correct. Thank you. It determines which entities are legal subjects, when legal personality begins and when it ends, and then what legal status involves and what effect certain factors have on a person's legal status. We're going to talk about all that. And then, so when we're talking about law of persons, we're talking about legal subjects. So you will find that we have two different kinds of legal subjects. We can call them two classes of legal subjects, where we have a natural person and a juristic person. I think that would be a great starting point for us today. First of all, we will start with what is a natural person and what is a juristic person. Is there anyone who wants to give it a try to tell us what a natural person is in your own opinion? Okay, so I would say a natural person or an entity subject to law. So a natural person is a human being, irrespective, for example, for their age, their mental condition, their intellectual ability, they are all recognized as legal subjects. So that is a natural person. So a natural person is a legal subject that can have rights, duties, and capacities. So how about animals? Do you think animals will be regarded as natural persons?
No, they are not regarded as natural persons.
Okay.
They do have rights to some capacity, but they are not recognized as natural persons.
Okay, thank you. And then juristic persons. So we said we have natural persons and then we have juristic persons. What is it that can fall under juristic person? What we can call a juristic person? Do you want to give it a try? So when we talk about a juristic person, we're talking about entities or associations or corporate organizations. So these things like, for example, let's say a university, Stadio. Stadio is a juristic person. Public universities, your companies that you register, those are their juristic persons because they are also recognized as legal subjects and they enjoy an existence which is independent that from its members. So if let's say you have registered a business, so your business becomes a juristic person because it exists apart from you, the person that registered it. So it's also a juristic person and it has certain capacities, competencies, and subjective rights. So the businesses, the universities, the churches, they all fall under juristic persons because they have juridical capacities, competencies, and subjective rights. And a natural person, we refer to human beings, irrespective of their age, their mental condition, their intellectual ability. Natural persons are regarded as legal subjects because they can have rights, duties, and capacities. And from all that, we exclude animals because they are not regarded as legal subjects. So Another definition of a legal subject, we can say, this is like an overall definition of a legal subject, regardless of a natural person or a juristic person. We can say a legal subject is a member of the legal community to whom the law applies, and for those who benefit, the law exists. And we also have something called legal subjectivity, which is the capacity of being a legal subject. So legal subjectivity is apparent from the fact that every legal subject is a carrier of juridical competencies, rights, duties, and capacities. So when you are faced with a question that says, what is a legal subject? You know it is a person or an entity that is subject to the law. So a legal subject, when they say what is a legal subject or what is a legal person, you must know that this question is a bit broad because it doesn't talk about a natural person, it doesn't talk about a juristic person, but it talks about both the natural person and the juristic person, because the answer to that would be a legal subject is a person or an entity subject to the law. And then if they say to you, how many classes of legal subjects do we have? You know that we have two. We have the natural person and we have the juristic person. And the natural person being all human beings, irregardless of their age, irregardless of their mental condition or their intellectual capacities. That is a natural person, and then they can have rights, duties, and capacities. Whereas a juristic person, we're talking about companies, organizations, associations, something that can exist on their own without the person that registered those businesses. Does anyone has a question before we move on? A question or a comment if you want me to repeat anything that I have said previously, if you didn't understand, because I know that sometimes I can speak very fast. So if it happens that I speak too fast, that maybe you're trying to take some notes, you can tell me, please slow down, Ghana, we're still trying to take notes. Is that okay? Okay, so let's continue. So today's session will cover, it's just going to be like a brief background as to what we're going to expect during the course of this module. So I will now share with you some certain concepts that we're going to cover on this module, some certain terms as well that you're going to see, so that when you're going through your study guide, you will not be surprised with certain terms, because there is a lot of Latin terminology and some kind of definitions that you want to know. So the general concepts of this module, you will find that if you have your textbook with you, there is a part that talks about status, the status of a legal subject, or the status of a legal subject. What that means is that it's a person standing in the eyes of the law, their legal capacity, their capacity to act, and their capacity to litigate and to be held accountable for crimes and delicts. So that is the status of a legal subject. So if we get to the topic of status, then you will have a brief background as to what that is. So that word status, you will see it a lot during the course of this module, and that word comes from a Latin word. I would say it's stare, or like S-T-A-R-E, if my memory serves me right. which means standing. So that is the position of the legal subject in a legal world, or the role the person plays in legal intercourse, or the functions of the person in his or her capacity as a legal subject. And then the next one that this one is actually it's a very broad subject area that we're also going to cover. It's domicile. Has anyone ever heard of this term domicile? Because I know it pops up a lot when you're signing contracts. If you have signed maybe a contract in the bank, or maybe trying to buy a house or rent a house or something like that, you usually see they will ask you, where are you domiciled, or something like that. I don't know how they usually put it, but before I even did law of persons, I think I had come across this term domicile a lot. So domicile is an aspect of law that influences a person's status. So domicile is usually a place where you legally reside. It's a very big subject area on its own, but I'm just going to go through it briefly. It's a place. So let's say, for example, you live in Randburg, and then in Randburg, that is your official address, and that is where, when you have anything like notices, mails, your registered address, maybe with the Department of Home Affairs, that will be regarded as your domicile. And then let's say you are studying at Wits University and you live there for the purposes of your studying, and then whenever you go back to your place in Randburg. So you are domiciled in Randburg rather than at Wits University. I don't know if that still makes sense. Sorry, can you please repeat the Latin term for status? The Latin term for status is stay. It's stay. I just put it on the chat box. I'm not too sure about the pronunciation of that word. You can research more if that is the correct pronunciation, but that is the Latin term for status. And then we will discuss age. So we spoke about status just now. So we'll also discuss age. Age is a very important factor that influences a person's status. You will see that as we move along, we will also talk about different ages, statuses, like from 0 to 6 years, from 7 to 18 years. Then from 0 to 6 would be infants. I don't have my book in front of me here. I think it's 0 to 7, which is what we call the infants. And then from 7 to 18, please, if that is wrong, please correct me, because I know you might have read that, but we're going to cover that as a subject area on its own. It's a very big subject area and it's very interesting. So 0 to 7 stand to be corrected. That is an infant. And then 7 to 18, that is a minor. And then 18 years and above, then it's a major, age of majority. And then we will also talk about the capacity of infants, what capacity they have. We will also talk about the termination of minority, that is when minority comes to an end. And then we will talk about the diverse factors that influence a person's status. That includes mental illness, and also include intoxication and many more. So we will also talk about capacity to act. So in a nutshell, capacity to act is the capacity to perform valid juristic acts. This especially deals with the capacity of a legal subject to conclude juridical relevant acts. And then this capacity to act, it deals with lawful acts. And these acts that are performed in compliance with the law, for example, a contract. So if you are able to enter into a contract, we can say that you have the capacity to act. If you are able to get married, then you have the capacity to act. And then we will also talk about capacity to litigate, which the capacity to litigate is like the capacity to appear in a court as a party to a suit. So if you have capacity to litigate, it means that you can be sued, you can sue. We will also cover that in broad detail. So it's a very big, law of persons is broad. We will talk about the capacity to be held accountable. We will talk about contracts. We will talk about curators. Curators refers to a person who manages another person's affairs on behalf of that particular person because he or she is not capable to do so. So I'll give you an example of one curator. So let's say somebody has, let's say I wake up tomorrow, I have mental illness problems. And then therefore I am not able to make valid decisions for myself. Then a curator will be appointed, and that curator will be able to handle my personal affairs that include making decisions for me. We're also going to talk about damages. It's going to be a very interesting subject area. So, so now we're going to talk about legal subjects. Okay, we've already covered that, what legal subjects are. We've already covered what two categories of legal subjects are. We spoke about a natural person and a juristic person. We spoke about what a natural person is and what a juristic person is. So who has yesterday? Who was here yesterday? Who attended yesterday? Anyone that attended yesterday? Or the first session, rather? Okay, so for those who attended the first session, we did talk about having a copy of the Constitution. So if you still don't have the copy of the Constitution, I did post it on the group. I can do a repost, but I think you can still find it under the documents on the WhatsApp group, or you can send me a message. Then I can share the copy of the Constitution for you, because it is very important that you have that copy of the Constitution, because everything that we're going to deal with, it's going to need you to have your copy of the Constitution. So let's talk about legal subjectivity. So we spoke about a legal subject. We said legal subject, it's either a natural person or a juristic person. And then legal subjectivity itself, in that manner, then we will be talking about a natural person. So legal subjectivity comes into existence at birth. So when a child is born, and that is when legal subjectivity begins. although this might sound like simple that if a child is born, then they're already a legal subjectivity. There are certain requirements that that needs to be met in order for your child that is born to qualify to being a legal subjectivity, to becoming a legal subject. So those requirements, you can find them on the on the Criminal Procedure Act. It's on section 239. You might want to make note of it, and then you can probably Google it or download the Criminal Procedure Act, or you can just buy it and keep it for yourself because you're going to need it in the future. But these are the requirements. You don't need to know what the Criminal Procedure Act says about everything. It's just for the purposes of this particular topic that we're talking about, because that is where the requirements of legal subjectivity are found. So the first requirement is that the child, or I don't know if it's the right way to call it a child, the baby or the fetus, it should be born alive. That is requirement number one. And then now that the fetus has been born alive, it should, it sounds weird when I say it, but it's a fetus. So it should have breathed, like when it is born, it should have breathed, and then it should be separated from its mother. So it should be able to live independently when it's born, right? So for example, let's say a fetus has been born, but it didn't breathe. You cannot say that person lived. So it obviously means that maybe the time that it was born, it was already dead, and it doesn't have any rights, and it's not going to be regarded as a person. So there is also certain meanings of words that we use. So you will see that I think yesterday and the day before yesterday, we spoke about the meaning. Yes, stillborn. Thank you, Precious. We spoke about the meaning of words that as law students, we have to be very careful with the type of words that we use. We have to know the meanings of those words, and then you will see that there is two different meanings of birth. For example, birth means the living birth of a child. So it means that that child needs to have been born alive. You can find those meanings on the. I will post this on the group. It's on the Administrative Act Section 1. I'll post this. Sorry, I'll post this on the group. So, in terms of common law, so I mentioned the requirements. That those requirements are under the criminal procedure, and then previously, or under the common law, they say the requirements are that the fetus must be separated from the mother. Not necessarily that the umbilical cord must be cut, but as long as the fetus is separated from the mother, then it meets the requirements of being a legal subject. And then the other requirement was that the fetus must have lived independently after separation, and any sign of life to prove that it was born alive will be needed. So let's say, for example, it was born and then it did breathe and then it died. So it means that fetus, so if it did breathe, then we can officially now call it a baby. And then if it took even one breath, then it would have lived. And then it means that this will take us to the next subject area that I would like to talk about. Like, let's say there was some kind of inheritance. We're going to speak about this in detail. So if there was some kind of inheritance for that particular child, then they will be able to inherit because they were born alive, they did live, and then now they are dead, but they will be regarded as somebody who was born and died. So we're now going to talk about the interests of the unborn child. So I'm not sure if you guys went through chapter 1. I don't know if I put chapter 1 and 2. I don't know if I did post it on the group. So the interest of the unborn child, they can be protected as well. So there is something called the Nasca-Curious fiction, or the Nasca-Curious adage. Yes, thank you. Let's put it there. Okay, it's already there. So it's either a fiction, and in some instances they call it the Nasca-Curious adage. So Gavin, is it Gavin? Am I pronouncing your name right?
It's Gavin AI.
Please repeat.
Gavin A.
Gavin A. Okay, Gavin A. So you read about the Nasca-Curious fiction. Do you want to briefly give us an idea of what you understood about it? I'm not putting you on the spot. If you feel I am, I'm sorry. do you want to?
I don't really know. I'm not sure, but I've seen the word in the textbook.
Okay, no problem. So the Nasca-Curious fiction, it protects the unborn child. It has to be at the advantage of the unborn child. We'll talk about that just now, but as much as it's at the benefit of the unborn child, the child should eventually be born alive. So we said previously, we said at birth, a legal subject with legal subjectivity comes into existence. So a legal subject or a person enjoys the protection of the law, but that where the unborn child also requires certain legal protection, that is when we bring in the Nasca-Curious fiction. So I'm going to give you a scenario. I didn't print out that case. Let's see if I have it on my notes. So there is a case. I just wanted to look at the. Okay, there is various cases that we can look at. There is a Pinchin versus Santam Insurance. Oh, okay. Can we please at some point discuss it thoroughly, because the Nasca-Curious fiction is question 3 in the assignments and it has 20 marks. Okay. Yes, definitely, Precious. We will we'll talk about that just now. Let me quickly open your. Okay, it's not necessary. It's fine. So there is cases that you can look at. We're going to discuss them briefly, or we're going to discuss one of them briefly. So there is a couple of cases. One of them is called as the pinching versus Santam Insurance. I'm going to type it for you here. And then there is a road accident fund versus Mtati. These are the cases that you're going to be hearing of for the longest time. And then we have ex parte Budal Steenkamp. Okay, so in common law, the common law has 3 requirements for the application of the Nascaturas fiction, and these requirements are very important for you guys to know. So first of all, the requirement number 1 is that the fiction must be to the advantage of the Nascaturas. So it must be to the advantage of the fetus. If the fetus in question will gain a benefit from the application of the fiction, then it can be applied. So one thing that you need to understand is that this is a fiction. That's why it's called Nascaturas fiction. It cannot be applied in general just because we want to apply it. No, there has to be a certain advantage that that baby or that unborn baby is going to benefit. If the baby is not going to benefit from it, from anything, or if there is no pending benefits for the baby, then it shouldn't be used. So so the requirement number 1 is that it must be to the advantage of the Nascaturas. If the Nascaturas infection will, sorry about that, guys. Just put that away. Sorry about that. So the application of the adage must be to the advantage of the Nascaturas. If the Nascaturas infection will gain a benefit of the application, it can be applied. The fiction can also be applied if the Nascaturas and the third person, for example, a parent of the Nascaturas, will benefit from the application thereof. However, if the application will be a disadvantage to this unborn child, then it must not be used. If the benefit of this, or the benefit that we're talking about, it must be of the Nascaturas after the date that it has been born. So the example that we're going to use is this ex parte Budal Steenkamp. I don't have the case with me, but I will just tell you what I remember. So the last requirement, before we go to this case, the last requirement is that the Nascaturas must be eventually born in the legal technical sense. So when we say must be born in the legal technical sense, we have to go back to the requirements of legal subjectivity to look at if the child was born alive, if the child was able to live or breathe or live independently when it was removed from its mother. So if it did meet those requirements, then the Nascaturas can be applied. So with regards to this ex parte Budal Steenkamp, so what happened in that case was that so there is this man, Mr. Steenkamp. Mr. Steenkamp was old and then he had a will. Guys, I'm going to continue just now. I see that we have less than a minute remaining and it will cut off. So please, if it does cut off, please join. The link is still gonna be the same. Then we can continue just now. So I will also repost the link on the group if you're having any difficulties to coming back in, because we have 40 minutes from Zoom. So it will cut off now. And then I will just, you just need to come back in. It says to me, it's less than a minute. So we're going to have 40 more.